Good afternoon. How was lunch? I know, right? Oh my gosh. I'm just going to pass out, so. Okay, yeah, are there any nurses here if I pass out? Any doctors left in the room? Yeah, nurses, doctors, all right.
Yeah, they want to listen to Medicaid right after lunch.
Yes, Patty's going to keep us awake. Well, I get the distinct honor of introducing Patty Sitchler. She is a local attorney. She is a shareholder in the firm of Schoenbaum, Curfey, and Scanlon here in San Antonio. Her clients routinely come in to plan for life and death with advanced directives and estate planning, and to preserve eligibility for government benefits such as SSI, Medicaid, and Medicare. And so Patty is a certified elder law attorney, one of only just a couple in San Antonio, by the National Elder Law Foundation, and is recognized by the Texas Board of Legal Specializations, easy for me to say. She was named as one of the best lawyers in America in elder law for 2007 through 2014, and is listed in Texas Monthly Super Lawyers 2004 to 2014. And anybody that knows Patty would agree. So she was named 2013 Outstanding Lawyer in Estate Planning and Elder Law by the San Antonio Business Journal, and she's an adjunct professor of law at St. Mary's since 1998, and co-author of a book entitled Elder Law. So I think we have someone definitely qualified. She's going to talk to us about Medicaid rules, do's and don'ts. So thank you, Patty.
Well, it's my distinct pleasure to be here with you guys. Anybody that knows me knows that I do like what I do, and I talk about law. And I was a little worried that I might not have enough materials, but then I was talking to one of my students and remembered that I always went over in class. So hopefully you will not be too sleepy. We're going to start with an enigma. Y'all remember what an enigma is? It's something that's puzzling or difficult to understand. And do we have any agency workers here? I know we have a couple. I've talked to a couple. All right. I think you probably will agree with me that it can be very difficult to understand the changes in the eligibility rules and dealing with tiers that I call HAL. Now you've got to understand I'm a lot older than most of you, so how many of y'all know who HAL is? It's not a who, it's an it. It's a computer from 2001, A Space Odyssey. Well, that's what tiers is HAL. And so you'll hear me say that, not in a mean way, but in a way that it's pretty controlling, and sometimes we have to do some adjustments. But anyway, this famous Enigma machine, if you'll remember from your history, in World War II, the Germans had this machine, and it had a bunch of dials on it, and you could just turn one dial, and if you didn't have the code, there was no way for you to read what the message. But if you knew the code, you could read the message, of course. And so I would venture to say that my colleagues and I believe that we needed an Enigma machine sometimes to interpret Medicaid. So I'm going to give you an example of sometimes our interpretation of policy and the rules regarding Medicaid. So, true or false? 4 is half of 5. Oh, no. No, it's true. And they gave me this cute little pointy thing. It's supposed to, I did it. I've got to hold it. Okay. You see that right there? IV, what is IV? Roman numeral 4. 4 is half of 5. And so that it's not about logic. It's about the rule. Is that the rule? That's the rule. 4 is half of 5 in this instance. And so when I teach at the law school, I'll ask my students, do you understand my words? Do you understand what I just said? I don't ask them, did that make sense? Because sometimes it just doesn't make sense. I'll give you another example. My clients will come in and say, but I can give $14,000. to anybody. The law says I can do that. I said, well, yeah, you're talking about IRS law. But Medicaid law says if you give away your assets for the purpose of qualifying for Medicaid, you lose eligibility. You can be penalized. Oh, okay, well, I can disclaim an inheritance, can't I? Well, the Texas law says you can disclaim an inheritance, but not for government benefits. That's a gift. I'll have people say, well, I just took Mama's name off of the account. Was it her account? Yes. Who owns it now? Well, I do. Well, that's a gift. And so working through gifts, attorneys out there, I don't know how often you do any of this stuff, but I will send a questionnaire out to people and say, please tell me if you've made any gifts in the last 5 years, and I'll have no circled. But I know I've got to hit that 6 ways to Sunday because they're thinking this gift with a bow on it. And so I'll say, okay, well, have you given anybody your car? Well, I gave it to my grandson. And I said, well, have you paid anyone's tuition? Have you let anybody use your credit card? Well, my daughter uses it all the time, but she's having a difficult time. Okay, so those are gifts that you're making. And so we've got to nail down what your gifts are. And so my role today is to help you break this Enigma code so that you won't have to, you'll have sort of a desk reference that you can refer to. And so many of my conversations will start with my clients. Am I running into this thing over here? That's, by the way, my way of waking y'all up, is all of a sudden you hear that screech. That speaker, okay, I'll try not to get too close to that. And so I'll have people call me and they will say, these are attorneys, they'll say, my client has some of that Medicaid stuff. and they're going to get some money and we want to know, are they going to keep that aid care stuff? And so I'll say, well, what do they have? Well, they have Medicaid, or they have disability. Well, is it Social Security disability insurance, or is it supplemental security income? Both require disability. Oh, they just have disability, and they've got some of the health stuff. And so I tell them there are over 40 Medicaid programs in Texas. There are, people will say, oh, I want some Medicaid. Well, there is no Medicaid stuff. And I can't talk without my hands. It's a good thing this little pointer, we would be all over. But anyway, there is no such thing as some Medicaid stuff. You access Medicaid through a program. And so you have nursing home Medicaid. You have 3 different, well, off the top of my head, 3 different kinds of in-home Medicaid. One being the Star Plus waiver, are for you people that have done it a while, CBA, that was the old community-based alternative, but now it's moving to Star Plus waiver. Same program, just a different name. There's a primary home care, or there's family care. There are programs for children. There's CLASS, the Community Living Assistance and Support Services. So you access Medicaid through a program. And so when you call and you say, well, will this affect my client's eligibility? You've got to know the program, because the reason I can make a living at this, every program has different eligibility rules. Every one of them. I mean, it may be just a nuance, but you've got to know that nuance. And so people will, I've been able to say, oh, well, if you're getting nursing home Medicaid, these are the rules. But if we move it to the home setting in the Star Plus waiver or assisted living, these are the rules. And so you can keep $60 in the nursing home, you can keep $85 in an assisted living, and you can keep $2,163 in the home setting. And that's just income. And so what I'm trying to say is there are all these different programs. So what you take away is know what program your client has. If you call me and you say, well, we just filed a disclaimer and I think we're going to have to withdraw it. You can't withdraw a disclaimer that's recorded at the county in the probate is irrevocable, and it's also can be a disqualifying transfer. And so be sure that you know what the requirements are, the eligibility requirements are for the program your client has, and the Medicaid eligibility handbook, and it's actually MEPD, Medicaid for the Elderly and Persons with Disabilities Handbook, MEPD, is on the internet. All you have to do is do MEPD Texas, and you can get that. Dr. Google will bring it right up for you. So what I'm going to do today is I've got 10 do's and don'ts for you. And I take questions, so if anyone has any questions, we will try to answer those questions for you real quickly, not as legal advice, but maybe clarify something. And I also tell my clients and my students there are no stupid questions. Believe me, there are no stupid questions, so ask your questions, that's perfectly fine. Don't say, I wish that Medicaid wouldn't pay the nursing home bill for people who are not legally here in the United States. I just wanted to clarify, this is right at the beginning. People who are not legally here in the United States, out of compliance, people who are out of compliance, used to a long time ago call them illegal aliens, don't get Medicaid. They can't get Medicaid. You have to prove citizenship in order to get Medicaid. So I just wanted to assure everyone that our legislature is good stewards of your tax dollars and making sure that these programs are only used for Texas citizens and for people who are legally here in the United States. And in fact, there are even limitations. If you're not a naturalized citizen, even if you're legally here in the United States, there are very, very limited benefits available for a person who is legally here in the United States. I only know of one benefit, and it's just a very minor benefit. Certainly, if you're laying bleeding in the street, we're not going to let you bleed in the street, no matter where you came from, and so the hospital will be paid. But other than that, it'll be stabilized, and then there's no Medicaid, no nursing home Medicaid, no in-home Medicaid. Don't tell people that Medicaid is only for people that have no money. In 1987, the Medicaid program was amended. That was back when Congress worked together, and they did pass a law that said a spouse is not going to have to be totally impoverished in order to get some assistance for the ill spouse. And we refer to it as the Spousal Impoverishment Act. If you're a single person, widowed, divorced, in other words, no spouse, you are pretty much indigent before you can get any Medicaid assistance. But if you are married, we have decided as a nation that we are not going to make you, the spouse at home, be totally indigent before we offer some help. And so you can protect up to about $117,240 for the spouse at home, potentially, and maybe even more than that if they have low income. And so I've attached frequently asked questions to this PowerPoint so that you will have sort of an overview of the Medicaid system. But essentially, if you have, when a person has to go into the nursing home, your husband goes into the nursing home, and the wife is at home, the Medicaid agency will ask to look at all of your assets, everything. So if you're considering a second marriage, you're not married yet, you're considering a second marriage, my advice is live in sin. because the Medicaid agency is going to look at your separate property as well as your community property. There is no separate or community property distinction. So your retirement account at TRS will be part of the equation, and the Medicaid agency says when you have a spousal situation, take all of their combined assets, add them all up, a house, a car, a prepaid funeral, those are exempt. There's a few other exemptions, including cattle and livestock for consumption. Texas is kind of unique like that. We exempt our cows and our chickens. But you have to put all your accountable assets on a ledger, divide it in half, and the spouse at home gets to keep 1/2, capped at $117,240. The spouse in the nursing home, the spouse applying for Medicaid nursing home benefits, gets to keep $2,000. If they have $1 million, that's it. If they have $100,000, it's a $50,000, $50,000 set aside for the wife, $2,000 for the spouse. So, but if you have low income, we can protect even more of those assets because we can use those assets to generate income to bring you up to a minimum income amount. And so don't tell people who are, at least who are married, that you can't have any money and get Medicaid, because under the Spousal Impoverishment Act, the whole point of that was to say it's for middle America. It is not for people who are totally indigent. Any questions? No? Okay. Don't tell someone, I apologize for that. I put my head down. Don't tell someone that they'd better give away all their assets if they're going into the nursing home. I hear this all the time. Well, we need for you to do a deed for us because mom's going into the nursing home and we don't want the state to take her house. If you give away your assets for the purpose of qualifying for Medicaid, we're just going to disqualify you for assistance. Medicaid is a state, a federal state cost sharing. The feds put about 60 cents of your income tax dollars, your general fund dollars in there. The state puts about 40 cents in. And so the law says we've got to be good stewards of your tax dollars. Therefore, if someone gives away the farm, and they could have, or all of their money, and they could have used that money to pay for their care, we're just not going to pay for your care. And so gifting for the purpose of qualifying for Medicaid is going to create a disqualification. You can give all your assets to your spouse. You can give your assets to a disabled child. You can even give it to a trust for a disabled person. And in some cases, we can give money away to grandchildren who are minor children. It's actually a rule specific to Texas. It's not a federal rule. But we let our grandparents pay for minor children's education. But it's specific rules on how to do this. And so, and the agency presumes every gift is for the purpose of qualifying for Medicaid. And so, if you tithe, you need to show them that you tithe on a regular basis. Well, someone said, well, how much did they get? I mean, what are they going to look at? Because they're going to look at your bank statements. $200 or more. We have to put an explanation on the application of what this $200 amount is. And by the way, round numbers raise a lot more scrutiny than odd numbers. But anyway, my clients, well, what if I just don't tell them? I'm just not going to tell them. Well, I'm just not going to represent you. because that's fraud. And we don't do fraud. No, 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 no. You need to be totally honest. Well, how do they find out? Well, the IRS and the Medicaid agency talk to each other. And your Social Security number is on bank accounts. And so the Medicaid agency will send a questionnaire to the IRS and say, here's the Social Security number. Send me all the bank accounts information about that number. And so they'll find out. They will. It's kind of like when my kids were teenagers and they thought they could get away with something. And I found out. Although they're now telling me. That's all right. That's another story. All right. So don't tell someone to put all of their assets in a Miller Trust. How many of y'all know what a Miller Trust is? Okay. One of the criteria for a number of the Medicaid programs, including nursing home and including that CBA Star Plus waiver program, the criteria is that you have to have low income. If your gross income is higher than $2,163 a month, you'll never get Medicaid, ever. And I just told you, if you give your stuff away, your money, your assets away, you lose eligibility. But we realize that nursing home costs $5,000, $6,000 a month, and so you can give away your income to a trustee so long as the trustee pays according to the rules. So the income will go in 1 month and has to be out of that trust. That trust goes to zero every month. And I'll have people call me and say, well, I need one of those Miller Trusts to put all that, hide the assets. And they really say, hide the assets. And I say, well, no, 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 you don't put assets in a Miller Trust. And my students, I tell them, if you put on your test that you can put assets in a Miller Trust, I'm taking points off. You cannot put assets. What are assets? That is not income. Income is what you get in the month. And if you still have that next month, it's an asset. It's your savings account. It's your ranch. It's your house, your car, your stocks and bonds and retirement plan. You do not put that in a Miller Trust. Miller Trust is also known as a qualified income trust. There's your word, income, or a QIT. So don't tell someone to run out and put all of their assets in a income trust or a Miller Trust, because you're liable, though it's a trust. And now they've got to get all those assets out of the trust. And a trust is a set of rules. You've got to follow the rules. And so it can be problematic. Number 5 and 6, I kind of combined those. Don't tell someone that the state's going to take your home and all of your assets when you go into the nursing home. And don't tell an individual the state's going to place a lien on the home. And I say that old style, a lien. Some people say a lien, but it's placing some sort of secured right to sell your house, placing a lien on your home. That is not true. Texas is not a lien, does not have a lien statute. So what this raises is Medicaid estate recovery. How many of y'all have heard that the state's going to take your house? They're not going to take your house. What the state has is, in 1993, as good stewards of your money, the federal government passed a law and said, look, if the state, we're getting the boomers are coming down the pike. There's a lot of people on these benefits. So if that person gets Medicaid, certain ones, not all Medicaid, but certain Medicaid, and then they die, if they have an estate, if their estate owns anything, the federal government said you the states can either put a lien on the house or on their property, or you can be a creditor, just like Visa or Sears. Texas resisted this law for 10 years. We didn't want to pass, that was 1993, actually. It was 2003. Texas was one of 3 holdouts and finally passed a law. But we didn't really want to pass this law, but it was a federal law and you're supposed to follow federal law. So when they passed that law, the legislature then turned to the rule makers and said, okay, we passed this law, but we passed the most lenient form of the law, the creditor statute, and we want you to write the laws and make it as lenient as possible. So the state limited estate recovery to the probate estate. Okay, for those of you who are not attorneys, I'm going to give you an example of something that passes outside of probate. Insurance. I can have a $10,000 life insurance policy. My policy, when I die, I have a contract with the insurance company to pay my daughter. She's the beneficiary of my life insurance policy. But my will says everything to my husband. So when I die, my husband goes to the insurance company and says, I'm the executor of her probate estate. Give me the insurance policy. Oh, no, no. There is a beneficiary designation on that. And so I'm going to, my daughter gets the life insurance outside of probate. So you can actually put that beneficiary, the only thing a person on Medicaid has is a house, generally. And so the spouse might have some things after eligibility, then we can transfer everything to the spouse. But the person themselves may die only owning a house or half a house. We can actually put that beneficiary designation on the house. It's called a ladybird deed, but what I'm telling you is that I just want you to understand that it's not against public policy to avoid estate recovery, but we do have estate recovery. It is not a lien on your home. It is a creditor statute, and it's limited to the probate estate. So the state is not going to take your home when you move into the nursing home. It's an exempt asset. As long as it's if you're a single person, it's got to be less than about $536,000. If you're married, there's no limit on the value. And then when you die, if that house is not in your probate estate, there is no estate recovery. But even if it is, it's not a lien statute, it's a creditor statute. And I tell attorneys, it's incumbent upon you to make sure that creditor has a valid claim. As of today, none of my clients have ever paid estate recovery because the state is not properly administering this. I don't think that it's there's anything sloppy or anything, but it's just that it's not. They're not jumping through all of the hoops that need to be jumped through. And as an attorney, I've got to bring those things to the attention of the agency and then request a release. And so you have to do your due diligence and make sure that there is no estate, that the state has a valid claim. And if they do, you've got to pay it. But it isn't a lien statute. Any questions so far? Yes. The question is, I'm going to summarize that. There are people in the community that desperately need an in-home benefit or even nursing home benefit. And the state is required to tell them in advance, if you get this benefit, you could have your estate subject to estate recovery. And so they'll refuse the benefits and put themselves sometimes at risk. And it's sad. It's really, really sad. And here's the unfortunate thing that I see is that this policy to make this lenient is probably aimed at people who are our poorest people in the community. But it's a legal device, and you need to talk to an attorney, and I charge a fee. I make a living at this, and there's a lot of bad information out there. But if I were to try to explain it to someone and say, look, the state has a right to recover from your probate estate. If your family is worried about this, they need to collectively go talk to an attorney with you to explain it to you that you can pass a house outside of probate. You can protect a house. But once the person is incompetent, maybe not. If that person doesn't have the mental capacity to sign documents, it may be too late. And so it's just like making a will. You need to make a will, you need to sign a power of attorney, and you need to discuss the fact that you might have to use Medicaid. I think to be a little bit more precise about the answer, how do you tell a person they need this benefit and the house may be subject to a state recovery? There are exemptions. Look, right here. It's on the 8001. That's the form that they use, the 8001. Here are exemptions. If your adult single child is living with you and keeping you out of the staying in the house, it may protect the house. If you have a disabled child, there's no estate recovery. If you have a surviving spouse, there is no estate recovery. It's erased. But in most cases, that's not the case. The only way to do this is to do it via a ladybird deed. This is something an attorney has got to draft, and only if the person has capacity or the agent has authority. And that's a good segue. Actually, I'm going to jump over here to 8, and I'll go back to 7, well, I'm the agent under the power of attorney. I can give away anything, or I can sign anything. A power of attorney is a written document that says, I'm going to see where I am. Okay. It's a written document that gives an agent the authority to do things for you, legal things for you. And it's only about 2 or 3 pages long, and it has a list of real estate and banking and government benefits and all kinds of list of things that an agent can do. But if you look in our statutes, it's pages of things that you can do. But there are things not on the list. An agent can't sign a trust for you. An agent can't gift your house unless you specifically give your agent the authority to gift your house. And so my suggestion is you need to read the power of attorney to see if there is authority to do that. So in doing that ladybird deed, it's a deed to protect the house from Medicaid estate recovery. My suggestion, an attorney needs to draft that deed. And the person who owns the house has got to sign the deed. But if mama's now so demented that she can't sign a deed, and I'm going to tell you as a notary, if you don't have the capacity to do this, I'm not going to notarize the document. And probably I won't draft the document. The agent says, well, I can sign it. Look, I'm her agent under the power of attorney. And I'll look on there, and it says, well, your mother didn't give you the authority to give away the house. I can't do it. We can't do it. So in creating these powers of attorney, you need to think about putting some authority in there. So don't use a power of attorney to make a gift if there is no gifting authority. If the Medicaid agency calls and says anything that makes you have heartburn, denied, ineligible, no benefits, anything that you think makes you uncomfortable, you say that you don't do anything. You don't say, well, I'll call you back, don't do that. Say, I appeal. And the worker might say, well, why did you say that? I don't know why. You said ineligible, I said appeal. That's what this lady said. You can always withdraw an appeal, but if you don't appeal within a very short window of time, you may lose your benefits. So if you're getting benefits from the Medicaid program and for some reason you lose them, if you appeal within 10 days of the notification, they continue the benefits during the appeal period. But my clients will say, well, I got this denial. And I said, when? Around the 1st of August. Okay. Well, you can still appeal, but they're not going to have any government benefits. And during that period of time, I feel for nursing homes. I mean, they've got to pay the light bill, and they've got to pay the salaries and everything, all of the overhead. And if you're not paying, they can issue what we call a 30-day letter, and you're out. They will deliver you to your last known address, and this happened. And so it's important to appeal it as soon as you can. Sometimes I'm not the easiest person to get a hold of, and so you say, well, I'll call you back after I talk to my attorney. No. You appeal now. We can always withdraw that appeal, always. But you may not be able to recover that 10-day period. So when you get anything that gives you heartburn, appeal it. How many nursing home administrators, workers do we have here? Anybody? Okay. As I just mentioned, nursing homes I have the greatest respect for the nursing homes. They've got to get paid. And the reimbursement, I think Texas is around 48th in reimbursement rates. 48th or 49th, something like that, which means that a person may be getting, the private pay rate may be $5,500 a month, but for this resident, Medicaid will only pay $4,500 a month or $4,000 a month, depending upon their level of care. And the nursing home must provide the same care for a resident on Medicaid as they would for a basic private pay resident. So I understand why it's important for nursing homes to get paid. So when your client goes to file an application, the nursing home says, well, we'll help you with it. I have undone so many boo-boos. And certainly these were not done. These mistakes were not done on purpose because the nursing home is actually shooting themselves in the foot because they're not going to get paid because of the screw up on the Medicaid application. But their concern is that if we don't have some control of this, the person won't file the application. And then it'll be problematic. There are some nursing homes in San Antonio and actually in the state that are now saying you will have to privately pay during the whole period of Medicaid eligibility if you file your own application or go to your own attorney. Or you can go to our Medicaid worker, our lawyer, and then you'll only have to pay a small amount every month. That's not legal to do. In fact, once you file that Medicaid application, the only thing the applicant has to pay is their income. That's all they have to pay. They don't have to pay the full rate. In fact, federal law and state law says it's against the law to condition residency in a nursing home on a family member, somebody else paying the fee. I understand where nursing homes are coming from. They've been burned so many times, and so they're looking for ways of guaranteeing that they get paid. But what I'm also seeing are botched applications. And I'm seeing, in one case, a spouse that had to spend down below their protected amount because the Medicaid worker for the nursing home botched the application. So they lost money. The family member lost money that they could have protected. And so work with the nursing home. Give them some comfort. Say, look, I'm filing the application for my client. You're not going to do it. I had one one of my clients said, the nursing home said they'll do it. And 7 weeks later, the administrator found it on the desk. So I file the application, or my client files it. But we'll give the nursing home a copy of the fax receipt showing that we faxed it in. We'll let you know. We'll let you know who the caseworker is. We'll keep you in, we will let the nursing home understand that we understand your concerns, but you be the advocate for your client. The nursing home has a conflict of interest. And so it's important to give that nursing home some comfort, but you advocate for your client. Any questions on that? Yes, ma'am.
Can a nursing home reject people if they're going to be Medicaid pending? Can a nursing home have a policy where they say we're not admitting somebody Medicaid pending?
Well, first of all, a nursing home has got to be have Medicaid beds. Not all nursing homes accept Medicaid payments. And then, in order to budget, in order for our legislature to budget, we have X number of Medicaid beds. And so some nursing homes are allotted 7. Another nursing home has all their beds Medicaid beds. It just depends upon how many Medicaid beds that nursing home has. Once you're in the nursing home, I think you have a better chance to make them give you that Medicaid bed. But I think it's just practical that if you aren't in there, they'll have somebody else that's going to go into that bed. It's hard to get into a Medicaid bed if the nursing home is not forthcoming and saying, we have 15 Medicaid beds and we've got only 10 of them filled, but we're not going to let you in because you're not privately paying. Keep in mind, in order to be eligible, you can't file an application until you're eligible. And in order to be eligible, you can't have any money. Now, the spouse at home might have some money, but if we're talking about a single person, they don't have any money. So how are they going to pay 3 months, the 2 months, possibly 3 months of nursing home costs if they don't have any money? And your family can't be financially obligated to pay. Did I answer your question? The question, sometimes you just don't know if there's a Medicaid bed there that you want to grab. Yes, ma'am.
So when I'm talking to a family and I'm wanting to refer them to somebody like you who knows the rules and can guide them through, when I say to them, I recommend that you get an attorney who knows this well and can help you, you know, conserve your resources, then how much should they, I mean, what's a reasonable amount to expect that they're going to pay you for your services?
You know, that's a hard question for me to publish my fees right here.
No, and I mean, I'm not asking your fees. I'm just saying what would be a reasonable amount so that I can say, you know, it's going to cost you between X and X for this so that they can plan for it. Because a lot of times I'll say you really do need to get an attorney and they will automatically, no, I can't afford one.
What's the house worth? I mean, you know, if you want to do the planning that you can for the nursing home and protect the house, and the house is worth $80,000, an attorney fee is pretty nominal. Let me tell you quickly, I'm going to answer your question, what my daddy told me. My daddy passed away when he was 96 years old, and in several years before that, I had insisted they get some help. Mom, who's younger than him, was taking care of him. And he asked me how much I charged, and I told him my hourly rate. And he asked me, he hesitated, how much do you charge? And so I told him again. He said, baby, I love you, but nobody's worth that much money. And so, you know, what happens is most of the time the kids pay. But what I talk to people about is, look, I require a couple of hours. And attorneys usually charge somewhere in the neighborhood of $250 to $300 an hour. $600 for our $800. There may be some extra stuff that has to go on, so it may be $800 or $900 for a consultation. But in my practice, what I do is, in that 2 hours, I'm going to give you the whole plan. And if you don't want to use me anymore, I'll tell you how to do it. I'll tell you the tricks of the trade. But if it's a complicated application, I'll tell you it's complicated, and Hal is going to eat your lunch. And so Tears has got some complications, and I know where those are, and I'll tell the family, more than likely in your case, because of all the complications, and then if I do a Medicaid application, it is expensive. It really is. But I'll tutor somebody through it so that they don't have to pay me the big fees. And I think there are other attorneys in our city and our state that do a similar type thing as well. And so there is a fee for this, but what you do is you look and see what you get for it. And if it ends up protecting your assets, or if it ends up protecting your home from estate recovery, then there's some value in that. And often that's where the kids protect that. I think I'm getting really close to about maybe 7 minutes
10, yeah.
Left. And right.
Hi, Patty.
Hi.
I just had a quick point. I have a really strange situation. I seem to always have really strange situations, but anyway, as an attorney, I put a ward, because I was the guardian, I put her in a nursing home as Medicaid, as private pay. We're going to, see how long the money lasts, and she was in her 90s, and et cetera. And then, if necessary, if the money runs out, we'll qualify her for Medicaid. So we got to the point where she was right there, the money was gone. We got about 2 weeks past that. We told the nursing home, okay, we're going to start the process. We started the process, started filling out the paperwork. She dies right then. So the nursing home is owed, they finally prorated at about $3,500 for this, 2 week period of time or what have you. They are so aggressively coming after that $3,500. I've never seen anything like it. They've sent me letter after letter after letter. There's no money in the estate.
Actually, what you can do is you can file that application and you can get up to 3 months of retroactive.
Okay, so we can go ahead and file the Medicaid application even though she died before, okay. So they may cover a couple of months.
They may cover a couple of months. But get that application filed really quickly.
Okay.
Okay.
Okay,
Yeah.
thank you.
And actually, the last one says, don't ever expect us to be logical. And it's not a criticism. It's, you know that old story, at least for when I was growing up, the old story of how did you build create an elephant by committee. And the next picture is a camel with two humps. And so, you know, you have all of these competing interests. You have the Congress and the legislature trying to protect our tax dollars. You have the community that is really aging and needing a lot of benefits. And so when all of those things, and you have actually some people that don't understand the program that get involved, and when you have all of those competing units in there, you come up with a program that has some unusual complications. Just like this, you can file an application for a dead person. Who would have thought? But you can't. And so just keep in mind that the Medicaid agency is, the workers, actually you can talk to them. They will talk to you. You have supervisors. Please be polite. My sweet daddy, one of the things my daddy taught, and he talked in cliches all the time. He said, baby, you get more honey than, flies with honey than you do with vinegar. And I remembered that. And be respectful to people. And then, and if you can't get any way with the supervisors, there's a program manager, a regional program manager you can go to. And then if that doesn't work, there is one lady in patty.seals at hhsc.state.tex.us. Patty, P-A-T-T-Y, .seals, S-E-A-L-S, at hhsc.state.tex.us. She can move mountains. This lady literally can move mountains. Don't pull that trigger unless you really have hit a wall. Don't overuse Patty Seals because she is the big boss. But when you have just tried, you've been diligent, you have given the worker all of the information over and over. It's been 9 months since you filed the application, and the agency is again asking for more information that you have given them over and over and over again. And you have talked to the supervisor and you've talked to the program manager. Nothing. You shoot Patty Seals an email, and my client was certified that afternoon. I mean, that's how powerful she is, and she's knowledgeable. And that's the thing, is don't be using that trigger for little things. Do your due diligence. Know what you're talking about, and go up the ladder, but she can make things happen. You're doing God's work if you're doing Medicaid, because the vast majority of the people really don't have a lot, and they would be in dire straits if they didn't have you as an advocate. It's been my pleasure. Thank you so much.
Valiente y